The end of a recent zoning board meeting, the township solicitor made a stunningly false statement.
Does not appear to be any objectors or protestants tonight, so there would be no possibility of any other parties filing an appeal.
Let's be clear, that's not how the law works. Zoning appeal rights in Pennsylvania do not disappear just because no one spoke up during the meeting. Appeal rights don't vanish just because residents were unaware, intimidated, or intentionally misinformed. The solicitor's comment wasn't legal guidance, it was damage control. And if township officials are that desperate to block appeals, you have to ask, what are they trying to cover up? Under Pennsylvania's Municipalities Planning Code and, relevant case law, appeal rights can be preserved even without verbal objection at a hearing, particularly when proper legal notice was not provided, procedural errors occurred during the zoning process, Sunshine Act violations denied the public a chance to participate, or a nearby property owner is directly and uniquely impacted. Let's take one example. In Kleissler v. Zoning Hearing Board of Monroe County, the court ruled that residents who didn't attend a hearing could still appeal if their property was affected. The standard is whether you are aggrieved, not whether you stood at a podium that night. And what if the township violated the Sunshine Act by failing to give proper public notice or, conducting deliberations outside public view? That too can make a decision ripe for appeal, regardless of how many objectors showed up. The solicitor's claim wasn't just wrong, it was strategic. It's actually a textbook example of how some townships use misinformation to silence the public. They want to discourage future objections, intimidate residents into thinking their window to act is closed and, avoid court challenges that might expose improper approvals. This tactic is not just unethical, it's a real betrayal of public trust. It shows that township officials are more interested in protecting their decisions than respecting your rights. Don't be intimidated by misleading statements. Know your rights, and challenge any action that wasn't done by the book. Make sure to document the meeting where these statements are made. If your property or neighborhood is affected, consult with a land use attorney. File a right-to-know request if the township is hiding information. And, appeal, if the law supports it. Let's say it again. The solicitor does not get to decide what is appealable. A judge does.